Did the defense discredit Erika Cheung on cross-examination? We're going to talk about that in the Sunny Balwani trial that's currently going on. And I'm also going to talk about what was the judge's response to the defense mentioning in opening statement the missing database. And we're going to get into that too. I'm also going to give you a scheduling update. And did you know that one of the jurors has already been excused? That was on Monday. The juror went out, was sick, called in sick. So the judge put in one of the alternates. So we have 5 alternates left. All right. So who am I? I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. And this video is for educational, informational purposes only, and I'm just giving you my opinion. And I welcome your opinions, your comments. Please do subscribe. Please share these videos, hit the like, and hit the notification bell so you'll be notified when I have upcoming videos. Okay, so in case you just popped onto this channel and you don't know who Sunny Balwani is or Erika Cheung, let me quickly fill you in. Sunny Balwani is currently on trial for 12 counts of fraud. Wire fraud, and the government is alleging that he, along with Elizabeth Holmes, she's already had her trial, and I'll talk to you about that in a second, but saying that Sunny Balwani allegedly made misstatements to investors and to patients, right? Defrauding investors, defrauding patients, and he's charged with 12 counts of wire fraud. Now, keep in mind, in the United States, every defendant, including Mr. Balwani, is presumed innocent until a jury comes back with their decision, whether they convict him, acquit him, undecided, we'll find that out. Now, Elizabeth Holmes was the CEO of Theranos, a blood testing company that she started. Sunny Balwani was the COO, and she was tried separately by a jury. She was convicted of 4 counts relating to defrauding investors, and that was in January 2022. Mr. Balwani is currently on trial and facing those very same counts. Okay, so Erika Cheung, she was the first witness for the prosecution in this case. She's currently undergoing cross-examination by Mr. Balwani's counsel. They're asking her questions, right? So did the defense discredit Erika Cheung's testimony? Erika Cheung, if you remember, she was a lab tech at Theranos. She worked there for about, I think, 6 months or so, and she quit because she has testified that she felt uncomfortable with the results and giving patients those results because she was uncomfortable about the technology and the testing. Okay, it's been a busy day, so hang with me on this one. So what did the defense do on cross-examination? And let me just tell you, the purpose of cross-examination is to test a witness. So you're going to, when I say discredit, in the sense of how's her memory? Is she truthful? Does she have a bias? Has she said something different before? Right? Those are many of the areas that we would get into on cross-examination of a witness, because a jury is going to be instructed and has been instructed that they have to determine the credibility of a witness. So is the witness honest? Do they have a bias, etc.? So what are the areas that the defense got into with Erika Cheung? What did they cross-examine her on? So I have to look at my notes here. They asked her, when she initially applied at Theranos, she wanted to get into the R&D section of Theranos, right? So she was initially hired into R&D, if I'm correct about this. She was initially hired in the R&D, and then she got switched to the CLIA lab. And so the defense was trying to point out that she was upset about that. Therefore, Erika Cheung was one of the whistleblowers, right? She was the one who made complaints and said there was problems at Theranos. So if she's a disgruntled employee, then maybe she made all this up. I don't know. Maybe that's what they're trying to get to. But they are testing her veracity and her credibility as a witness, right? So what does Erika respond? She responds, I think I was initially upset about being switched into the CLIA lab, but it was fine. Okay, so the jury can determine, as well as you, can determine whether or not you think that discredits her. Okay, so the next area that they went into on cross-examination, the defense, they asked her whether she signed an employment agreement, a non-disclosure agreement regarding disclosing any of the intellectual property at Theranos, right? And if you want to go look at my video that I did on the whistleblowers, you can find out about Erika Cheung. And if you also want to go look at, in that whistleblower video, I did show you the text where they were trying to figure out about the trade secrets, protecting the trade secrets of Theranos, which every business owner has the right to do. So why did they ask her? Why did they ask Erika Cheung on cross-examination whether or not she signed this non-disclosure agreement? Well, because if she signed the non-disclosure agreement and she went and talked to reporters, being the source for the Wall Street Journal that John Carreyrou wrote and blew the whistle on Theranos, right? And Erika Cheung also, I think she filed a couple of complaints with the federal regulators, letting them know about her experience at Theranos. Well, if any of the intellectual property was discussed, if she disclosed any of that, then, question is, can she keep her word? If she signs an agreement to say that she's going to abide by non-disclosure. And again, this is just my opinion, right? Maybe this is what the defense is getting at. I don't know. You tell me. But, is she to be believed? If she says, on one hand, yeah, I agree not to talk about intellectual property, but on the other hand, she's over here talking about it. Is that one way of discrediting Erika Cheung? Let's see. All right, what's the next thing that the defense did on cross? They went over the SOPs, the standard operating procedures at Theranos, because if you remember, and if you look at, I think it's a whistleblower video, and I think it might be some of the prior highlights videos that I did, where Elizabeth Holmes and Balwani, I know what it was Tyler's video, the math tutor video, right? Where Elizabeth and where Sunny Balwani asked and suggested that maybe Tyler should get a math tutor when Tyler was calling out what he saw was going on at Theranos, and he saw the discrepancies in the results he was getting. So you can go look at that video that I did. I think it's called Tyler Calls Out Elizabeth Holmes. Anyway, so let me get to my point here. So the point is, in that video, if you watch it, you will see that Elizabeth Holmes and Sunny Balwani were concerned that these lab techs, of which Erika Cheung was one, and the rest of them, if they were doing the procedures properly, if it was a problem of human error, in other words, the lab techs were screwing up, it had nothing to do with whether or not the technology worked. Because in this case, the prosecution is alleging that Balwani and Holmes, but Balwani in this case, made representations that the technology was accurate and reliable. But if you can say has nothing to do with the technology, it has to do with whether these lab techs were screwing up and not following the SOPs, then that's a problem, right? So the defense spent a lot of time going over the standard operating procedures with Erika Cheung. And they asked her, was it basically her job to make sure that the SOPs were accurate regarding the testing, the results. And, again, that's going to whether or not there were the errors, the unreliability of the test was due to human error, or whether it was due to the error in the technology. Okay. So again, that's something the jury's going to have to figure that one out, right? So what was another area that the defense went over in cross-examination with Erika Cheung is they asked her basically whether she worked on modifying any of these commercial devices and whether or not she validated any of these tests. So they were pointing, and she said she didn't work in that area. She didn't modify the devices, nor did she validate any of these tests. So that helps the defense say, okay, well, she can't give any information. She can't give the jury any information on that. She can't talk about that. So, they were narrowing down what she could talk about. Okay. And that's another thing that you want to do on cross-examination. I hope this is helpful to you guys. I hope I'm making sense here. All right. So when the trial resumes, and this is where I'm going to get to scheduling, Erika Cheung is still going to be on cross-examination. All right. So cross is going to continue. So as far as scheduling goes, it turns out that one of the jurors has a wedding to go to. So I don't think trial is going to be, I think trial will resume next Thursday. I'm not sure. I'm waiting to get confirmation on that. So no trial on Friday, no trial on Tuesday, no trial on Wednesday. And it looks like the jury's coming back on Thursday. And I'll double check and I will keep you posted if there's any changes, because one of the jurors has to go to a wedding. Okay. And that happens. All right. So let's get into what did the judge think about the defense mentioning the missing database. Remember the database, the Theranos database that contained all the results of the patient's tests. It contained all the quality control results, right? And, as I said in the last video, in my opinion, that's probably the best evidence, right? Whether or not this technology works or not. But I think if you watched the prior video, I talked about how this database was initially produced to the government, but they weren't given the key, the access code to get into it. So they were given a database they couldn't get into. And then the software and some of the, I think it was the software or the hardware or whatever, I don't know. This is above my pay grade, okay? Anyway, they weren't able to use the content of the database because they couldn't get into it. And so the judge had made an earlier ruling in the Holmes case, the co-defendant of Balwani. She was tried in January, right? Or September through January. That the judge made a ruling in that case, in the Holmes case, that they had to be very careful about this database in the sense that if they were going to mention it, they couldn't get into what really happened to it, right? Because that was the judge's ruling. So in this case, in Balwani's case, it was pretty much, if I'm correct about this, pretty much the same ruling that you could, maybe the defense could talk about the missing database, but not really blame, they said that the prosecution was dragging their feet and that they didn't, look into this database. I guess, therefore, it's the prosecution's fault, right? That Balwani can't use that database to, as the defense is alleging, to show that he's not, to show that those results were accurate and reliable. Okay, so because the defense brought it up in opening statement, and again, opening statement is not evidence, but because they mentioned this missing database, remember that I said maybe that's planting a seed of doubt. Because they mentioned this missing database, they opened the door, and you don't ever want to hear this as an attorney, that you open the door or the other, potentially the other side opened the door, because that's letting us know that, what, we were supposed to be, the evidence and the testimony around that issue was limited and we could only go so far. And when someone opens the door, in this case, the defense opens the door, the other side, the prosecution, could have an opportunity if the judge decides this. And guess what the judge said so far? They're still discussing how they're going to handle this. Now, this is not to say the defense did anything wrong, right? But the judge said this is a serious issue regarding how they're going to handle this missing database now that it's been brought up, right? The bell has been rung. So, and if you remember the missing database, what happened to it was that it was I think it was the hardware was dismantled 4 days later after the database, the unusable, I can't say the word, you know what I mean. They couldn't get into that database, and Theranos dismantled their hardware and I think the key code or whatever 4 days later. So they couldn't retrieve it, right? And in the judge's prior ruling in the Holmes case, he basically, said that, looks like there's some issues here around how that evidence was handled, but the judge found it was not the government's fault. So again, this is kind of a difficult situation to be in, and we're going to find out what the judge does. What's the remedy here? One of the remedies could be instructing the jury, okay, you heard this and you're not supposed to consider it. Maybe the judge will say that, or the judge might say limited to, you can only consider it for this purpose. Or the judge might say at the worst case scenario, would be a mistrial. The judge could have a mistrial if he thinks that it was so unfair or unfair to the people that this happened. And I'm not saying it's a mistrial. I'm not taking any judgment. I'm just giving you this information to let you know what's going on, okay? So a mistrial, what's a mistrial? And this is great because I get an opportunity to teach you, right? A mistrial is when is something a judge can do or either party could ask for, right? To have the case start over, new jury, start all over because there was some prejudice that happened. So normally this might happen, say, let me give you a bad example. A prosecutor gets up an opening statement and starts talking about how the defendant's not going to take the stand. Well, we all know the defendant doesn't have to take the stand, right? They have the Fifth Amendment, the right to remain silent. Well, that would be very prejudicial towards the defendant to say that. So that would be a circumstance where a mistrial could be granted. So whether or not mentioning a database amounts to a mistrial, I don't know. We're going to find out. But the Fifth Amendment in the US Constitution talks about double jeopardy, right? So once a jury is sworn in, and this jury has been sworn in, double jeopardy attaches, meaning the defendant, Mr. Balwani, can't be tried twice. He's currently being tried, right? So another trial would be tried twice. So maybe double jeopardy applies, right? And I'm just, again, we're just talking about this. Not that it's going to happen, but I'm just trying to teach you about what mistrial is about, right? And what double jeopardy is about. So we'll see. And again, on the 29th, so that's next Tuesday, we have a motion to dismiss on calendar in front of the judge relating to the defense's motion to dismiss. And I'm sure they're going to be talking about how they're going to handle this missing database, whether or not they're going to let testimony in to talk about what happened to it, or whether the judge is going to decide, we're not going to talk about that, and I'm going to instruct the jury, X, Y, and Z. I don't know. We're going to find out, but it's very interesting. So those are the highlights. I hope this has been informative and helpful to you. I hope you learned a couple things. So anyway, please do subscribe, leave a comment, please share, like, and hit the bell notification. And thank you very much for watching.